Hello and welcome to this talk on the Employment Tribunal Rules of 2013. My name is Declan O'Dempsey. I'm a barrister at Cloisters Chambers and I'd like to deal with costs, preparation time and wasted costs in this talk. I want to start with some definitions. Then costs means essentially all the legal expenses. In the rules they're referred to as fees, charges, disbursements or expenses incurred by or on behalf of the receiving party, and that includes expenses that witnesses incur. In Scotland you use slightly different terminology, and except in relation to wasted costs you refer to expenses. By Rule 83 the tribunal can order the paying party to pay for any allowances paid by the tribunal to a person who's attending at the tribunal in connection with the case. Next, I want to have a look at the concept of being legally represented. This means having the assistance of a person, including that of the receiving party's employee, if that person has the right of audience in England and Wales courts, or is an advocate or solicitor in Scotland, or a barrister or solicitor in Northern Ireland. On the other hand, represented by a lay representative means that you've got the assistance of a person other than the legal representatives who charges for representation in the proceedings. A cost order means that the paying party has to make a payment to either the receiving party in respect to the costs that the receiving parties incurred while legally represented or while represented by a lay representative, or to the receiving party in respect of an employment tribunal fee paid by the receiving party, or a payment to another party or witness in respect of expenses which have been incurred or which are to be incurred for the purposes of or in connection with an individual's attendance as a witness at the employment tribunal. A preparation time order is an order that the paying party must make a payment to the receiving party for the receiving party's preparation time while they were not legally represented. Preparation time means time spent by the receiving party, including their employees or advisors, in working on the case, except for time spent at any final hearing. A costs and preparation time order can't both be made in favour of the same party in the same proceedings. The employment tribunal is allowed to decide during the proceedings that you're entitled to one order or the other and defer until a later stage deciding which kind of order to make. One of the key features of the costs orders, wasted costs orders and preparation time orders that we're about to have a look at is that the tribunal may have regard to the person's ability to pay when they're considering whether to make an order that this person should pay, and also at the stage of how much the person should pay. There are several bases on which costs can be ordered. By Rule 76, a tribunal must consider whether to make a costs order or preparation time order, and may make a costs order or preparation time order if it considers that the party or their representative has acted vexatiously, abusively, disruptively, or otherwise unreasonably in either the bringing of the proceedings, or part of them, or the way that the proceedings or part of them have been conducted. It can also make an order for costs and must consider whether to make an order for costs, etc., if it considers that any claim or response had no reasonable prospect of success. The second basis is that a party has been in breach of any order or practice direction, or if the hearing has been postponed or adjourned on the application of a party, so that if the tribunal itself decides of its own initiative to adjourn or postpone, and isn't doing this in response to an application, it's not allowed to make a costs order on this basis. The third basis relates only to unfair dismissal cases in which reinstatement has been sought. So in unfair dismissal cases, if the final hearing is postponed or adjourned, the tribunal must order that the respondent pays the costs incurred as a result. A couple of preconditions must be fulfilled, however. One, the claimant must have expressed a wish to be reinstated or re-engaged. Now that wish need only have been communicated to the respondent not less than 7 days before the hearing. There are other reasons why, if you were seeking reinstatement or re-engagement, you'd want to do it much sooner than that, because it affects the viability of the order. But for these purposes, if the claimant has expressed a wish to be reinstated or re-engaged, and that's been communicated to the respondent not less than 7 days before the hearing, and if the postponement or adjournment has been caused by the respondent's failure without a special reason to adduce reasonable evidence as to the availability of the job from which the claimant was dismissed, or of comparable suitable or suitable employment, then the tribunal must order that the respondent pays the costs. The fourth basis is where a party has paid a tribunal fee in respect of a claim, an employer's contract claim, or an application, which has been decided in whole or in part in favour of the party. So this is a discretionary ability of the tribunal, which relates to the new fees that are paid to the tribunal. Notice that it's not necessary for the claimant or applicant or counterclaimant to have won all of the case, and it would be possible, for example, for there to be costs orders both ways in a tribunal case where it was felt appropriate, so that the fees that have been paid by each side in such a situation might be claimed against the other side. The fifth basis relates to other parties or witnesses, and relates to expenses for the purposes of attending as a witness. The tribunal can do it of its own motion, or the parties may apply for this type of costs. You can apply for a costs order or preparation time order up to 28 days after the date on which the judgment finally determining the proceedings in respect of you was sent to the parties by the tribunal. The paying party must have had a reasonable opportunity to make representations, either in writing or at a hearing, and that is up to the tribunal, in response to the application. I want to turn next to how much can be ordered. The tribunal can order a specified amount of up to £20,000 in terms of costs. Now, all the other aspects of the amount that can be ordered can exceed £20,000. So another way in which the costs may be ordered is that the paying party is ordered to pay the receiving party all or a specific part of the receiving party's costs, and that amount is going to be determined by a court in England and Wales, or an auditor of the court in Scotland, or by an employment judge in accordance with the same principles as would be applied in the court or by the auditor of a court. So in England and Wales, that's the Civil Procedure Rules of 1998, and in Scotland, it'll be the Act of Sederant, the Fees of Solicitors in the Sheriff Court Amendment and Further Provisions, 1993. Next, the paying party can be ordered to pay to the receiving party a specified amount, which can be reimbursement of all or part of the employment tribunal fee which the receiving party has paid. So that it would be possible, for example, for the tribunal to order half of the fee paid to be paid by the paying party, so that the amount which the receiving party has successfully obtained from the tribunal can be reflected in the amount of the fee which the paying party is ordered to pay to the receiving party. So if you only win 50% of the claim, then you may only receive 50% of the fee paid. The tribunal can order costs or expenses in respect of witnesses or another party. Again, remember that these amounts can exceed £20,000. They're unlikely to, but conceivably they might. And then finally, the tribunal is, of course, able to order the payment of the amount that's been agreed by the parties. A particular issue arises in relation to lay representatives' rates. So a lay representative, remember, is somebody who's charging for their representation, but is not a legal representative. If the cost order includes an amount of fees in respect of fees charged by a lay representative, then when you're calculating the amount of the order, the hourly rate is applied, so that at the moment, and up to the 5th of April 2014, £33 an hour is applied. So that is the lay representative's rate. On the 6th of April, and annually on that date, that amount increases by £1. How do you calculate a preparation time order? Well, essentially, a preparation time order is the hourly rate times the assessed hours. And Rule 79 deals with the approach to assessed hours. The tribunal decides the number of hours in respect of which a preparation time order should be made on the basis of the information provided by the receiving party on the time spent by them, including their employees or advisors, in working on the case. This doesn't include the time spent at any final hearing, but the basis also includes the tribunal's own assessment of what it considers to be a reasonable and proportionate amount of time to spend on such preparatory work. In reaching that assessment, it'll have regard to matters such as the complexity of the proceedings, the number of witnesses, and the documentation required. So it's sensible to address those issues if you're applying for a preparation time order, and to point out if the case was particularly complex, deal with the number of witnesses. Of course, they need to be necessary witnesses. And also, if there's been a lot of documentation, then do think about the amount of time you actually spent working on these documents. I want next to turn to wasted costs orders, which are dealt with in Rule 80. This is an order against a legal or other representative for the receiving party if the receiving party's incurred costs as a result of any improper, unreasonable, or negligent act or omission on the part of the representative, or if the receiving party's incurred costs which the tribunal thinks unreasonable for them to pay in the light of the act or omission which occurs after the costs were incurred. So a representative can be a party's legal or other representative or employee of such a legal representative. It doesn't include a representative who's not acting in pursuit of profit, but if the representative's acting on a contingency or conditional fee basis, then that will be regarded as acting in pursuit of profit. The receiving party may be the representative's client, but not if the representative is employed by the receiving party. So in-house lawyers and in-house representatives will not find their employer coming after them for wasted costs, although in the situation in which they've behaved in a way which would attract it, they're likely to face other sanctions. The effect of a wasted costs order is that the representative can be required to pay the whole or part of any wasted costs as defined, or the tribunal can disallow any wasted costs which would otherwise be payable to the representative. The representative can be ordered to repay any costs which have already been paid. The amount to be repaid, disallowed, etc. must be specified, however, in the order. When can you apply for wasted costs? Well, the tribunal can order wasted costs either on its own initiative or on the application of any party. A party's got up to 28 days after the date on which the judgment finally determining the proceedings as against them was sent to the parties. The representative has to have a reasonable opportunity to make representations, either in writing or at a hearing, in response, and the tribunal must inform the representative's client in writing of any proceedings under the Rule 82 and of any order made against the representative. We're coming now to the end of this series of talks on the tribunal rules, and I want to just outline some other rules which are there in Schedule 1 and point out the other two schedules to the tribunal rules, but these rules are rarely needed by individual respondents or claimants. So Rule 93 deals with the requirement to notify ACAS of proceedings and their ability to attend. Rule 94 deals with national security implications on evidence, etc. 95 deals with the position on interim relief hearings. These interim relief hearings generally don't receive oral evidence, although it is possible to have it at the discretion of the tribunal. Rule 96 deals with National Insurance Fund cases. Rule 97 deals with cases in which it's claimed that a collective agreement discriminates, and it requires the employer and any workers' organisations who are likely to negotiate a variation of terms which are in issue to be included. Rule 98 deals with devolution matters. Rule 99 deals with the transfer of proceedings between England and Wales and Scotland. Rule 100 deals with the ability of the tribunals to make references to the Court of Justice of the European Union, and tribunals have used this power in several cases over the years. Rule 101 deals with transfers from courts. You might have this in relation to an equal pay claim, which has been transferred from the county court. Rule 102 deals with the position of vexatious litigants and the ability of the tribunal to notify the requisite people. Rule 103 requires certain information about proceedings to be given to the Equality and Human Rights Commission in relation to various complaints under the Equality Act 2010. Rules 104, 105 and 106 deals with particular appeals which the tribunals hear and who are the appropriate respondents and claimants for those appeals. So that's Schedule 1. Schedule 2 deals with national security rules, and I suggest that if you have anything that's approaching national security issues, that you approach a solicitor and obtain legal representation. Schedule 3 deals with the procedure for equal pay cases, and again, if you are involved in that sort of case, it would be very much worthwhile obtaining legal advice. Thank you very much.